So, let's talk about homeowners associations. You know, HOAs. They're these hyper-local governments that can tell you what color you can paint your door or what kind of flowers you can plant. But what happens when that power is used to, well, completely rewrite the entire rulebook for your neighborhood, seemingly overnight?
I mean, really think about that. You wake up one day, and the foundational rules of your community, the ones you agreed to when you moved in, have been totally swapped out. This isn't just some hypothetical question. It's exactly what happened in one quiet, 39-home neighborhood, and it turned the place into a battleground over procedure, power, and who gets a say.
This is the story of the Prince Court Homeowners Association. And look, this wasn't a fight over something small, like loud parties or an overgrown lawn. No, this was about the very foundation of their community rules, and it came with a really serious allegation, that the board used an illegal process to change them all.
And let's be super clear here. This wasn't just a tweak to an existing rule. A homeowner was claiming the board pushed through a total replacement of the founding documents. You know, the covenants, conditions, and restrictions, or CC&Rs. That stuff is like the legal DNA of the neighborhood. The whole fight was over how they did it, not just what they did.
To really get what's going on here, we have to rewind the clock. We need to go all the way back to the beginning, to the guy who wrote the original rules for Prince Court back in 1997, a developer named David Zinfeld. What he originally intended is totally key to this whole story.
And wow, during the hearing, Zinfeld's own testimony was, well, it was powerful. He made it crystal clear that his vision from day one was for a community-led association. He wanted the homeowners, the actual members, to be the driving force behind any big decisions, not a small, isolated board.
And you can see that philosophy baked right into the original process for making changes. It was designed to be slow, deliberate. You had to start a full year in advance, have open discussions with the entire community, and it was structured to take so long that multiple elected boards might have to weigh in. It was all about making sure the homeowners were on board.
Okay, so that was the blueprint, but the process the HOA board actually used in 2024, it looked nothing like that. Instead of that slow, open discussion, they went with a much faster, shall we say, more streamlined approach.
Just look at this timeline. It was way more condensed. It all kicks off with hiring an attorney in April, a brand new draft gets sent out in October, and the whole thing comes to a head in a single notary session in December where homeowners were asked to sign consent forms. A very different vibe.
And here's a crucial detail. Testimony from the HOA president confirmed it. There were 0 open community meetings to debate these new rules. The board said all the discussion happened over email, which, of course, means if you weren't on that specific email list, you were completely out of the loop.
Now, this is a really key piece of the puzzle. In an email sent on October 14th, the board explicitly told homeowners that they would get the chance to vote on the new rules. That word, vote, it sets a very clear expectation, right?
But that promise of a vote, it never actually happened. Under oath, the HOA president clarified what really went down. There was no formal ballot, no simple yes or no vote. Instead, the board just collected individual consent forms at that one meeting. It might sound like a small difference, but legally, it's a huge one.
So, all of this ended up in a formal administrative hearing. This is where the homeowner's challenge was finally heard, and it's where these two totally different ideas about the right way to change the rules officially went head-to-head.
And get this, the whole challenge almost fell apart before it even began because of a single typo. The official complaint cited the wrong article number, Article 5 instead of 7, and the case almost got tossed out on a technicality. It just goes to show you how much every single little detail can matter in these fights. So, at the end of the day, the arguments boiled down to this. The owner-homer said the process was just fundamentally broken. It wasn't open, it wasn't inclusive, and it wasn't what was promised. The board, on the other hand, defended their actions. They said they were just following their lawyer's advice, felt an open meeting would be a mess, and that letting people ask questions over email was good enough.
All right, so let's zoom out from Prince Court for a second. What's the big picture here? Why should this one neighborhood squabble matter to any of us who live in a community with an HOA? Well, because it touches on some really big universal ideas about how we govern ourselves.
This whole case really forces us to ask some important questions about our own communities. Is there due process? Is our board transparent? Do we as homeowners have a real voice in shaping our neighborhood? Or can a tiny group just make huge changes on their own?
So here are the real practical takeaways for any homeowner out there. 1.
know your rules. Seriously, read your governing documents so you know how things are supposed to work. 2, document everything. Keep a paper trail. 3, participate. Show up to meetings. And finally, remember that the process, the how, matters. As this case shows, how a decision gets made is every bit as important as the decision itself. Being informed is your single most powerful tool.
And that brings us to our final thought. The story of Prince Court isn't just about one set of documents or one board's decision. It's really a reminder for all of us to look at our own communities and ask a simple but really powerful question. When it comes right down to it, who really holds the power to make the rules where you live? Thanks for watching.